Good afternoon, everybody. Thank you for joining us for another Senior Advocacy Forum. My name is Brian Tully with Tully Law Group. And like always, we're going to get started in about 2 minutes. Just give some time for people to log on, and I'll be back shortly. All right, everybody, we're going to get started for our next edition of the Senior Advocacy Forum. Today's today's topic is guardianship, the who, the what, when, how, and why. And we have two guardianship experts joining us today, which is wonderful. So today's going to be a discussion about guardianship and the different aspects of it, what it is, why it's necessary, how it's helpful, and how to avoid it. Okay, if we can help it at all. Our Senior Advocacy Forum is our monthly webinar series sharing insight from different leading professionals in senior care, legal, wellness, covering all of those topics as it pertains to our clients and to, of course, our communities and our loved ones. What I'm going to do right now is stop sharing my screen, but I'd like for somebody to please let me know in the chat box or the Q&A box that you can see and hear us. I want to make sure all the technical glitches, or there are no technical glitches. So in the Q&A or the chat, if somebody could just let me know we're all good. And it's usually the same one or two people that do it, so I hope you do that for me. Yep, we're good. All right, great. Thank you. Thank you. I appreciate that. Okay, so again, guardianship. Some states call it conservatorship, but here in New York, we call it guardianship. And I'm going to say it's a necessity. It's a court proceeding where we're able to help loved ones, we're able to help strangers, we're able to help people that are in need, not able to make their own decisions or handle their own legal affairs. Today is not legal or medical advice in any way. It's not financial advice. And we're dealing with two busy professionals, so here we go. It's interesting. So we have two guests today. Joanne Hawthorne is joining us. Joanne is one of my partners here at Tully Law Group. She specializes in guardianship, estate planning, probate, as well as estate litigation. She was admitted to the New York Bar back in 1994. She holds certifications as guardian ad litem, as court evaluator, as attorney for the alleged incapacitated person, which we'll be explaining today, as counsel to the guardian, and even as a supplemental needs trustee. She receives appointments in both the Surrogates Court and the Supreme Court in all boroughs of New York and Nassau and Suffolk counties. We're grateful to have Joanne join our team because she helps us provide these much needed guardianship services to our clients. And we also have with us Bob Heppenheimer. He founded Guardianship Corp, which is a 501c3 not-for-profit. And the mission of Guardian Corp is to take on guardianship appointments for those that are indigent, or those without family or friends willing or not able to serve as guardian. The nonprofit was originally funded by New York State grants. It's currently funded by the Suffolk County Department of Social Services for a 40 client caseload. Since its founding, Guardianship Corp has been appointed to over 100 temporary and permanent guardianships of persons and or property in Suffolk County. Guardianship Corp was designed to deploy volunteers, students, and paid staff to visit clients more frequently than average. Prior to his service in the guardianship community, Bob was a licensed nursing home administrator and has both owned and served as executive director for numerous nursing facilities over his 50-year career in healthcare. I've known Bob for a number of years as well, and we're fortunate to have him and Joanne, again, two experts in this field. So let's get started. So Bob, you first, please. The title, guardianship, the who, what, when, how, and why. Let's start with the what, okay? So Bob, from your perspective, nonprofit perspective, how would you best explain what a guardianship is to somebody that doesn't know?
Absolutely. Thank you, Brian. Thank you for inviting me. Guardianship is a legal process that occurs when an application is made to the court. Somebody is in the community and unsafe. Somebody is in a nursing home and has no one to advocate for them. Or somebody has shown up in an emergency room and admitted to a hospital, and there's no one there to make decisions for them. Right. So somebody, whether it's the hospital, the nursing home, a neighbor, or a family member, applies to the court that a guardian somebody is needed to look after this person, whether it's their physical being and their well-being, their medical care, eating, shopping, versus their property, their real estate, their income. Someone has to be able to get their assets and be able to pay their bills so that they can continue to get care. So it usually occurs in some type of emergency situation. Although, as you know, there are cases where there are disabled children for whom guardianship will be needed, and it obviously is more of a planned process than an emergent process. Right.
Understood. Right. And again, through your nonprofit, you're helping those in Suffolk County, serving as guardian when it's needed. Right.
We were formed primarily because there is such a unmet need in the community due to a variety of reasons, people living longer, both in terms of different populations, as well, people outlive their guardian and somebody else is needed. People live with more chronic diseases, so they end up outliving their spouse, outliving their kids, or they may have had not so good family relations, moved away, or they may have had no kids and their spouse dies and they are left alone, and all of a sudden they are in need.
Yeah, understood. And Joanne, before I get to you, Joanne, I didn't mention, if there's any questions for our viewers, please feel free to type your question into the Q&A box or the chat box, and we'll get to your questions at the end. So Joanne, we get calls at times, right, where we're dealing with perhaps a loved one that no longer has capacity, perhaps a cognitive decline has taken its toll, or there's been an immediate decline where something has occurred, such as a stroke, and there's no other arrangements made. So Joanne, can you share from the law firm's perspective? We'll get into the when is it necessary later, but what exactly is it? And as Bob alluded to, there's different types of guardianships. So if you could talk about the two types of guardianships and what we see.
Sure. So primarily what happens is we do get these intake calls, and we find that someone will call and say, I need to get a power of attorney for my mom. And that's not how this works. It's not something you get, it's something somebody gives. And if they're calling and asking for it, usually by that point, they don't have that advance directive in place. So they give me the situation, they will describe the loved one or the friend's situation, that they don't believe that they have the capacity at that point in time to be able to execute these advance directives. And then they're looking for some other alternative through the court system to be able to get them the authority that they need to act on that person's behalf.
Right.
And that takes place in two different court scenarios. There is the Supreme Court, which is called Article 81 of the Mental Hygiene Law. And there's also Article 17 and 17A, which takes place in the Surrogates Court.
Okay. And so can you explain, Joanne, the difference between those two? Because they apply generally to different populations.
Well, they can apply to the same people in some capacities. The 17A is supposed to be in the Surrogates Court, is a more streamlined process that has a specific categories that have almost been, I don't want to say pre-approved, but they've been recognized by the court as requiring the necessity of a guardian in place. A lot of times those have with developmental disabilities or intellectual disabilities, things like autism spectrum come into play. And those tend to be more often the case of a parent that's dealing with a child that's turning 18 and realizing that their child may be on some sort of spectrum or have some sort of developmental or intellectual disability. And when they become 18, unless they are adjudicated and incapacitated by the court, the parent doesn't have the right to be a part of any medical decisions or financial decisions. So that's one process that can go through the Surrogates Court. And like I said, it's supposed to be a more streamlined process to get these parents or family members in charge. Article 81 is a much broader proceeding that's brought in the Supreme Court in counties. Basically, it's brought in the county in which the person resides or the county in which they may be in a hospital or a nursing home. And that is a petition to the court to basically ask for broad powers. You can ask for very specific one power that you may need. It could be just limited to be able to open a certain account to access a certain fund, or it could be completely broad powers for both property management and personal needs. So it kind of depends on what you're looking to do. Sometimes the Surrogates Court can be a little too restrictive if it has to do with property, because the property management through Surrogates Court requires the surrogate, the judge, to be involved throughout the lifetime of the child. And that may not give the parent or the family member the flexibility they need to do financial transfers or estate planning that they may want to do. So those are usually brought in the Supreme Court instead.
Got it. So what we're seeing from what I'm hearing from the both of you is that when there's a need, when there's a person, a loved one, a neighbor, somebody in the community that no longer has the ability to perhaps help themselves with their property issues, concerns, bills, finances, or perhaps they're no longer able to help themselves with their personal decision-making, their healthcare decision-making, that a guardianship can then become appropriate. Ideally, and I'll say this from the elder care estate planning perspective, ideally, a power of attorney in place, the right modified power of attorney in place, as we call it, would be the workaround here. So that's the advance directive that Joanne was alluding to, so that you can name somebody of your choice to handle legal and financial affairs and hopefully avoid, if it's the right power of attorney, avoid the guardianship proceeding altogether. So Bob, from the nonprofit perspective, when are you being contacted? Is it by the families? Is it by the court itself? How does that work?
If I may, though, we get appointed by the court, so we are sort of the end of the process. But if I may, I do want to sort of highlight a little bit more the difference with the Article 17 versus the Article 81. Article 17 is, from my perspective, is more diagnosis driven. If you have, as Joanne said, the spectrum diagnosis, the court then gives you plenary powers and you are on your way to guardianship. With Article 81, it is not a mental capacity decision. It is a global physical as well as mental capacity. Is somebody able to take care of themselves? They may be cognitively able to take care of themselves, but not physically. I have 40-year-old clients who are cognitively capable of doing everything, but are physically disabled due to MS or other diseases that they cannot write out the checks and pay their bills. So it is Article 81 is a broader definition of what constitutes the need of a guardian. And there's also what's called a person in need of a guardian, a PIN. That's somebody like as this example I gave you, he actually applied to the court and said, I need help. So it's a process that's being forced upon him. It is something that he is agreeing to. So if a client agrees to a guardian, they do not then get determined as an incapacitated person. They are known as a person in need of a guardian. And the legal determination of their capacity is not necessary in that process.
Yep, good point.
So that being said, Joanne, you want to chime in?
No, I was going to say, to elaborate, yes, the Article 81 is a functional, the standard is the person suffers from functional limitations, and their inability to understand and appreciate the nature and consequences of these functional limitations will cause them harm if a guardian is not appointed. It's not about diagnoses, it's not about Alzheimer's, it's about looking at their activities of daily living, their ability to manage their finances, and making an adjudication that the person suffers from these functional limitations.
Right. So that's a good point. And I think the distinction that Bob was making there as well is, right, the 17A is really, right, Joanne, as you were saying too, it's about the diagnosis, whereas the 81 is not. The 81 is going to be about a functional decline and a functional need. And what I've seen through the years, and of course these two know more about it, but the 81 can be so finely tailored based on what the needs are. It's not a broad removal of every single decision-making authority. It can be finely tuned based on what the needs of the person in need requires. Go ahead, Bob.
Every single case that I have, Article 81, each client has their own individual powers that is uniquely given by the judge for the need. There is no need, then there is no granting of that power. And if I need more powers, I then have to go back to the court and for them and give a reason for them. So the goal of a guardianship from the judge's perspective is sort of the least intrusive. Judges are very leery of taking away people's rights. So they really want to make sure that they are curtailing a guardian to do only what they need to do. There is a need beyond that the guardian has to come back and have a conversation for that.
Good. Right. Absolutely. And that's the way it should be. We're talking about some very serious issues. Joanne, can you share the different parties, right? So you have your petitioner, so if you can go through the 3, 4, 5 different people that, or the titles you might see.
Sure. So I'm speaking about, this is Article 81. When there's the petitioner is the person that's going to hire the attorney to apply to the court, believing that someone else is in need of a guardian. At that point in time, what the attorney would draft is something called an order to show cause, which says to the court, this person needs help, and here's the date and time that the judge fills in when the hearing takes place. And the hearing is supposed to take place within 28 days of the signature. At that point, you also submit with that a verified petition from your client, which is basically the narrative stating why they believe that this person suffers from functional limitations and why they will be harmed if they don't have a guardian appointed. Those two things are filed with the court. And if the judge signs the order to show cause, the date is given. The court also then appoints other parties to be a part of this proceeding, because as you said, the judge does not want to take away someone's rights without a thorough investigation into their life and what's going on and the allegations in the petition. So one of the first people that's appointed, that's always appointed, is a court evaluator. A court evaluator is an attorney like me who is on a list called the Part 36 list of eligible appointees. And it's an attorney usually, it could be a social worker, that has taken a course and is certified to act as they call it, the eyes and ears of the court. That person is a neutral. Their role in the proceeding is to read the petition, speak to the petitioner, speak to all of the interested parties that are listed in the petition, which may be other family members, social workers, people that reside with the alleged incapacitated person. And they then formulate an opinion and draft a report, which is entered into evidence at the hearing and becomes a part of the record and basically provides some guidance to the judge to give them an advanced look at what's going on. Now, if a temporary guardian is appointed, which sometimes people need even in the 28 days might be too long to wait. If a temporary guardian is appointed, the court's always going to appoint an attorney for the alleged incapacitated person. Again, it's an attorney on a list who's got experience with this. And what their job is specifically to represent the alleged incapacitated person. They don't offer their own personal opinion. If the alleged incapacitated person wants to object, that is their position, and that is what they advocate for. Mm-hmm. And so these parties all get together on the hearing date, and usually, if there isn't any opposition, or even sometimes if there is, all of this takes place in one, anywhere from 2-hour to 4-hour hearing, where evidence will be put on by the petitioner, and the other attorneys have an opportunity to question anyone that's put on the stand to make these allegations of incapacity. And the court evaluator then gets to take the stand. Their report is entered into evidence, and they get to testify. It's called testifying in the narrative. Basically, you just reiterate your report, the highlights of it for the court, so that if any of the parties have any issues or questions, they can address it there. Mm-hmm. And usually, if everything goes smoothly, the judge renders the decision right then and there. Mm-hmm. So those are the players in these kind of proceedings. So it's not just one person making an allegation and the judge agreeing to it. There's safeguards here to protect the alleged incapacitated person's rights.
Right. So you've that phrase. So alleged incapacitated person, that's the person we're concerned about that this is proceeding is for. Okay.
Exactly.
Right. Now, Bob, from your perspective, coming in or being appointed, you've been appointed as guardian. You serve as guardian. You're not at these hearings, are you? You come in after the fact.
Usually 99% of the time, I receive a call from the judge mm-hmm. that I've been appointed, or I just simply get it in the mail that we've appointed.
Mm-hmm. And then what does that role look like? What do you help with?
Well, as I call it, it's jumping into someone's life doing 90 miles an hour. I will say there have been 1 or 2 times where the judge will call me up and say, I have a case. Would you come to the hearing and meet the AIP and see whether they like you and you like them? Mm-hmm. So there's a little, every so often there's an interesting case like that. Otherwise, we jump in. If they're in a hospital, obviously we reach out to the hospital. We find out what the situation is. Are they on a ventilator? Are they stable? What are the end of life discussions maybe? Or, can we get them out, and how quickly can we get them out? Mm-hmm. What are their benefits? Do they have Medicaid? Are they a citizen? All of these are critical to make sure, that the process can start to move. If they're in a nursing home, usually there's some issue with Medicaid that we have to figure out where their funds are. One of the important roles of a guardian of property is to marshal the person's assets, meaning to go to their account, to the bank, and close those accounts that are in their name and place those accounts into a guardianship account on behalf of that person so that we start to pay their bills, change of address so that we can start to see what their mail is and things like that. If they're in the community, obviously, to make sure that their rent is paid, the lights are being paid, the cable is being paid, and just primarily it's ensuring their safety, healthcare, well-being immediately. As I put it, you sort of triage it. Is somebody bleeding or we're dying? If not, okay, then we go to the next stage. And then if we can always improve their lot in life, if we can get them out of a nursing home or get them into a better situation. Otherwise, we visit with them, we advocate for their care. If there is family, we work with families. Usually if there's family, the family gets appointed. That's the normal, customary way. But sometimes family is either dysfunctional or just not willing to step up. But that doesn't mean that we don't try to keep them involved. While we are the appointed legal guardian, this is somebody's spouse, this is somebody's parent, and that certainly is not preempted, in my opinion, by the guardianship, if they're acting reasonably and in the person's best interest. So we jump into their life and we just try to keep them safe and keep them stable.
Right. Good way to describe it. Joanne, when you were talking about the parties, you mentioned the hearing and you said if there's no opposition. So what does that mean? And what would opposition look like in a
Okay.
guardianship proceeding?
I've always said though, I do enjoy this kind of litigation only because even if there is opposition, even if it's contested, everyone is still usually trying to do the best thing for the alleged incapacitated person. It's just sometimes the opposition usually takes place when you've got dueling family members. One family member may bring this petition because they may feel that another family member is exercising some sort of undue influence or not taking care of the AIP properly. And so, like I said, the interested parties are the other family members, people that may reside with them, and they have the opportunity to object. They have the opportunity to put on a reason why maybe they should be appointed over someone else. Though it's been my experience that if there are dueling family members, a lot of times what ends up happening is the court appoints a neutral. The court says, look, we're not going to get in the middle of this family argument that's never going to get better. We're going to pick someone off the list, like Bob's organization or other attorneys that are on the list of eligible appointees, and they become the guardian. Now, as the appointed guardian, nobody ever wants to be making decisions for someone else's parent or someone else's family member. So as Bob said, if there are other families members involved, they're always going to be a part of the decision-making process. There are rare occasions when the alleged incapacitated person also objects, and they can even demand a jury trial. There is a right, it says right on the order to show cause that you have a right to a jury trial, and they could, on their own with the representation appointed by the court, seek to have the entire proceeding dismissed. And it's not unheard of that happens.
Understood. Please.
I would comment, there are early stages of dementia that are very difficult for the court and or just professionals to tease out. And those, I think, are the greatest challenge, because they will come to court and say, I don't need a guardian and I'm fine, I'm not crazy. But when you ask them questions and you try to assess their judgment or their plans, they're just not there. And I think the difficulty is that people have the ability to have capacity for certain things in life and then not other things in life. And judges are very leery of taking away people's rights. They seem like nice people and they communicate beautifully. But when you really go beyond that, they really are in need and respectfully need a guardian, or else they will end up, I had one case, the lady was found on the LIE in a broken down car with a dog, feeding herself scraps. I was appointed temporary guardian. It was before COVID, so COVID sort of extended the guardianship beyond what should have been. But when the permanent guardianship hearing was held, the judge decided that woman did not need a guardian and terminated the guardianship. And about 2 months later, she was back in the hospital, the hospital applied for the guardian. And this time, the guardianship was appointed. The woman is socially wonderful, but cognitively, absolutely just not there. And it's very hard for a judge to sort of gauge that, or anybody, because when you simply, again, in the early phases of dementia, when people can hold a conversation, it's a really tough thing to ascertain.
Sure.
Am I willing to take away this person's rights in total?
Right. Well, that's the beauty of that court evaluator role, right? To get a little more insight, hopefully spend a little more time, and also the benefit of the hearing if the AIP does appear at the hearing. But also gratefully, that's why the 81 can be tailored so much. Now, before we started, both of you mentioned the word accountings. Okay. Now here we are in the month of May. All right. So Joanne first, if you can share. So if you're appointed guardian, is that it? No, right? You have to account. You've got to do. So why is May important from your perspective?
Okay. So on May 31st, the ruling is when you're appointed as a guardian, that there's certain accounting requirements. And the judge will go through this in the guardianship hearing to anyone that is applying to be the guardian, and they want to make sure that the person that's applying is they're up to the task of what they're going to have to do. After your initial appointment, there's something called a 90-day report, which has to be filed with the court, which basically goes over the different assets that may have been brought up in the hearing. A lot of times, by the time the hearing rolls around, nobody really has the authority to find out what the assets are, to go to the banks. The banks won't talk to you. Right. So the 90-day reports kind of sets the stage. By May 31st of the full year that you've been the guardian, you have to account to the court and file this. The order will tell you who you have to file it with. But after a guardian is appointed, there's someone called a court examiner, who is sort of like a supervisor for the guardians. And you have to write this report. It's a very detailed, scheduled report that shows what money was brought in, what money went out. It has to balance, which is key. And then you have to file it with the court. You also have to file it with your court examiner. The court examiner then gets the backup documentation, such as all of the bank statements, copies of every check that was written, copies of the bills that came in, and they are the overseers that then have to run through the account to make sure everything is right, everything is justified. And if that is the case, then that year's accounting is approved. And if any commissions are earned by the guardian based on the assets that they're managing, those commissions will be awarded at that point in time. Unfortunately, most courts are running 2 years behind, at least, on guardianship accountings. Even when the court examiner gets them filed, then they still have to go through the second step with the court and get signed by the judge, the order approving the accounting. And so it's a tedious process. Right. And it has to be, as long as if you're collecting assets, you have to account. That happens every year by May 31st, which is rapidly approaching.
Now, Bob, you had shared you've been working on a bunch of them. Similar perspective, right? You still have to, even as from a nonprofit perspective, you still have to comply, and everything has to be accounted for. Is it just on the financial side, Bob, or do you also have to establish what you've been doing on the personal side as well?
Absolutely, you have to provide documentation, doctor's visits, a full accounting of what you've done, the visits you've made. Again, most of my clients are in nursing homes and assisted livings, so their care is all on site. But clients that are in the community, if you're taking them to the doctor or you're coordinating their care, or they have a care manager, I usually attach any kind of care plan that's been developed, show the oversight. If I may, there was one document that I'm sure Joanne will remember. Before you can even do your 90-day report, before you can act as a guardian, you have to receive the commission from the county clerk. Sure. So before you can act, you have to take the order that the judge gives you and send that into the Suffolk County Clerk's office with a check and a cover letter, and then receive back the stamped document that is your actual commission. And that is what empowers you to go to the bank and have them authorize you to close accounts and things like that.
Now, Bob, a family member can also be a guardian, right? But there's training for that?
Absolutely. Family members are preferred. Again, certainly for guardians of person, you take care of this person like you would a family member. So that is always the preferred. But there is a training course that you have to go. It's online. I think it's a 90-minute video that you have to watch and record some of the passwords that document that you listen to it, and then get a certification that shows that you went to the training course. As a non-for-profit, we don't have to do that because we are a guardianship company, but individuals do have to do that. I often will help family members sort of get their documents done, because while they're really not terrible documents in the scheme of things, they are very intimidating to people who are not attorneys. Yeah. So the first time you do these documents, you're sort of, bare knuckles. By the second or third year, it's sort of like, it's really not difficult, but the first time we do anything, it's scary, and it's the court, and it's getting things notarized, things like that. People are intimidated by that. So Guardianship Corp, one of the missions we have is to help folks, because it's always better to have family members do this, and we can help with the intimidation of the documents.
Yep.
I think that's an important role to play.
Good. Thank you. So Joanne, a quick question, well, maybe a quick question and then a broader question. If a child brings this for a parent, brings a guardianship petition over the parent, if they're not doing it in good faith, are there certain risks that petitioner, that child can face? I mean, right? I mean, if they bring it and it's dismissed, there's fees, there's concerns.
Yes, and again, it's rare, because normally someone is not going to go to these lengths, or especially if they're going to hire an attorney. When I'm retained, I obviously vet the clients to make sure that this is appropriate and necessary before you go and file something with the court.
Right.
But there have been occasions where if someone will start a petition and they'll withdraw the petition, and you also have to warn the client, or they should know that if they, if there is something about this that is, wasn't completely above board, and now they're withdrawing the petition, they could be held responsible for all of the fees that need to be paid. So again, the court evaluator needs to be paid, the attorney for the AIP needs to be paid, and these payments come from the funds of the alleged incapacitated person, normally, if there are any, if everything's successful, because the idea is it's for their benefit. Now, there are circumstances too when there are no funds. And in those cases, and it's happened to me more than once, as the court evaluator or the attorney for the AIP, you just don't get paid. There's no money there. But as a deterrent to someone bringing one of these actions with bad, in bad faith, they could be held responsible for all of those fees if it is determined that they should not have done this.
Right.
So that's a little caveat there.
And so before I get to the other part, so Bob, that's where you come in as a court-appointed guardian. You're funded, right, as we shared in your introduction, by the county. So if there are no funds, are there more people like you, Bob, or no, more nonprofits in that role?
There is a guardianship program EAC runs. They take on cases that APS applies for. But as far as I'm aware, New York State has no public guardianship process.
Do other states?
There is, yes, other states do have some processes for a public guardian. New York has nothing, and nothing was put into the budget this current year. So it really is a huge hole in our safety net that the state has not created any system. There are a couple of non-for-profits dotted around the state that do similar work. There's a large non-for-profit in the city that takes on hundreds of cases, but they are also funded charitably as well as by the city. Right. But it really is a great public issue that, as Joanne knows, because folks in the guardianship world know, this is, my company would not exist. Right. But if not for this need. We were called by the judge at the time, who was so desperate to find decent guardians, because while attorneys can be asked to do this work pro bono, there's only so many pro bono cases that an attorney should take. And by the way, it's really inappropriate for a judge to be asking an attorney who works with them to be doing pro bono work like this. So, and candidly, once the guardianship is established, guardianship is 99% not legal. So it really does not take attorney skills for much of the work. Sure. It's just that there needs to be some organized system, like we have, child services for children, adult protective services. There needs to be some agency in the state that at least this issue is home to. And there's not even an agency that sort of deals with it in New York State. So it's a big advocacy issue, and certainly, as you can hear, I'm quite passionate. Again, if not for this need, we would not be here.
Certainly, Bob, sounds like you've got your mission cut out for you. There's a bigger need there, a bigger purpose there.
So as I said, as people are living longer, you might have a plan for someone to take care of you when you're 70, but when you're 90, that person is no longer alive. We don't really plan to end up by ourselves, which, does lead us to sort of the issue of how to avoid guardianships And just to be clear, as you know, if you have a valid healthcare proxy, if you have a valid power of attorney, then you have gone as far as you can go, pretty much, to avoiding a guardianship. If and when you do those documents, certainly with a good attorney, if you can also create what's called a MOLST, which is medical orders for life-sustaining treatment, that takes your wishes of healthcare advanced directives and puts them into a format that doctors and hospitals will honor. And it's a critical document in the aging spectrum. So, as you know, those documents will go a long way to either avoiding a guardianship or informing a guardian of what your wishes would be if you find yourself at 90 in a state by yourself.
Great points. I'm glad you did that. So Joanne, before I get to my last question, I'm just going to take a moment. So the powers of attorney, the healthcare proxy, also what's called a living will or a MOLST, as Bob mentioned, that's another document with a healthcare provider. Usually it's completed. We've covered those in prior webinars. So if anybody wishes to learn more about those documents and what a power of attorney should look like and not look like, as well as asset protection, the Medicaid's come up as well. Our website has 3 years worth of webinars covering all of those topics. That's tullylelderlaw.com, Tully, elderlaw.com. And you can see those webinars there and get that background information. Or if you wish to talk to us, of course, we provide free consultations on these guardianship concerns as well as planning and protection. Joanne, last question before we wrap up. And I also know you've got a guardianship conference in 17 minutes. So the last question, Joanne, you said 2 years before. That was to get the annual report reviewed. A guardianship proceeding from start to end, contested or uncontested, they take about how long?
Best case scenario is from the time you file, the order to show cause is usually signed within a day or two, and the hearing is supposed to take place within 28 days.
Right.
So you file May 1st, you're looking at the end of the month if you're lucky. Once the guardianship hearing is over, let's say the easy one, the guardian is appointed, now it's a paperwork issue. The attorney for the petitioner now has to file the order appointing the guardian. That is sort of a reiteration of all of the powers that have been approved and have been accepted, and a lot of other paragraphs, because the guardianship order is a manual. And that's the manual you're going to look back at to see what you have to do and when and who needs to know. That drafting that can take a bit of time. You need to get a copy of the transcript from the hearing, which can take a bit of time. So even that, from the time the hearing ends to when the order is signed, could be 4 weeks to 2 months. Then you have to get your commission. That's it's best case scenario. Something gets contested or something gets adjourned.
Right.
Usually in those situations, a temporary guardian will be appointed if there's an urgent need. So it's almost not as critical that the time frame moves faster because there is somebody in place. But I've had some, they can go on for 6 months if there's that much going on that requires investigation. And a lot of times with the contested ones, there's no winner. It's not that this person's going to win over that one. Nobody wins, mom or dad. What usually happens is everybody comes to some sort of settlement agreement where the best interest of the AIP is what's in the forefront, and everyone sort of gives up on their individual, getting over on the other party. But those can take a lot longer.
Yes, understood. All right, so I have 2 questions, but before we get to those, Bob, is there anything else you wanted to share that we didn't cover today?
I just want to make sure if anyone wants to know more about us, our website is guardiancorpny.org, GUARDIANCORPNY.org. And otherwise, if anyone has any questions, we certainly are, available. We're not attorneys. We simply can advise as to the process and maybe a little bit more.
Understood. Joanne, anything else you'd like to share? I do have 2 questions here, but did we cover everything you want? All right, good. So first question, is guardianship information private, or how can you find out if someone is in guardianship, and if yes, who's overseeing it? So who wants to answer that one? Okay, Joe.
I'll go. It is absolutely private. It's restricted. So there is a system, an e-file system now has been in place. It's come more into favor during COVID. It's called the NYSIF, New York State Electronic Filing System. But guardianship proceedings are restricted. So you actually have to be a party or an attorney for a party to be able to see anything that's gone on in the transcript or, you know, in the history of any of this. It's very difficult to get access to it otherwise.
Yeah, good. Understood. And there's a good reason for that, right? I mean,
Yes,
it's privacy,
absolutely.
it's HIPAA and so forth. All right. So Bob, does the court-appointed guardian have to go to court to make a decision regarding end-of-life choices if it's not specified in the order?
If it's not specified in the order,
Yeah.
then yes.
Yeah.
But usually, if you are granted powers of the person, usually there are specific clauses that grant you the power to make these decisions. So as Joanne said, you know, you have to go back to your manual and see, but certainly 95%, I can only think of one case in all of my cases that we did not have that power if we were guardian of person. Again, if you're guardian of property, you're not involved in that decision making at all. But usually those, you know, cases are covered by the powers, and you know, we consider prior wishes, you know, what their situation is, what their quality of life is,
Sure.
you know, and if we can get any information from family or friends, you know, they're very difficult decisions to make.
Sure.
Certainly, you know, you don't want to prolong human suffering, and candidly, you know, I hope at some point there's somebody there when I need it to make those decisions in a compassionate way.
Yeah, understood. Quick question just popped up. If an unrepresented AIP in a nursing home, does an unrepresented person, AIP in a nursing home, need a guardian to get the COVID vaccine? Have you come across that over the last couple of years, Bob, with the nursing home?
Unless you're declared incapacitated, you have full authority as a nursing resident to get the COVID vaccine. So there's never a question that a nursing resident can't get it.
Yeah, but if there is no capacity.
Well, if they're under guardianship, they will ask the guardian. I've been notified multiple times for my guardianship boards, but otherwise, unless, like he said, unless someone is declared incapacitated, they should be going off of what either the family member who is listed as the, you know, contact for healthcare decisions.
I think what you're pointing out though is a different definition of medical versus legal terminology, because somebody can, as a licensed nursing home administrator, I can have somebody who I know has dementia, who is, in my mind, incapacitated, but they're not declared legally incapacitated.
Sure.
As such, until that happens, unless the home wants to go, but unless there's a reason why they would need to go, to go through the expense of getting a guardian to authorize that.
Understood. We're just getting a couple more questions, then we got to wrap up. So, Bob, the correct website is guardiancorp, corpny.org.
Correct.
Okay. In the absence of family, we'll use a physician consent. All right. So that was a comment that was made. Okay. So I want to thank everybody, our viewers, for joining us. Joanne, thank you very much. Bob, thank you very much. I know you both have been very, very busy these days, especially in May. Next time we'll do this in a different month. So for our viewers, you will be getting emails announcing our next webinar. It's going to be May 24th. May is also National Older Americans Month, and it's also National Elder Law Month. The topic for our next webinar is going to be how estate planning documents can help a client keep control, can help an aging loved one keep control and autonomy through their planning. So sign up for that once you do get those invites and the registration information. Thank you again, Joanne, Bob. Thank you for our viewers. Everybody enjoy the nice weather. Great. Bye-bye.